A patent troll is it can be sometimes a lot of debates happen over the subtle definitions here. A patent troll is a company that exists only to amass patents and sue or threaten to sue people for infringement. That has no business model besides suing people or threatening them.
That is their
asking
business.
for money. Yeah. We just recently put up on our site an interview with this person who would have had his entire business sunk by a patent troll if it had not been for that Alice v. CLS Bank decision that we were talking about earlier, where a judge correctly had that patent invalidated under the Alice decision. When we talked to this guy, and he described getting this demand letter in the mail and saying, I think it might have been $30,000 that they were asking him for when he was just this new startup with a staff of like 1 or 2 people. And there was no way he could have afforded to pay that. And the patent, and it's a classic example of the kind of patent that both under the law and just kind of under basic common sense shouldn't be valid.
Are you able to say?
Yeah. It's this company called My Health. And again, they have no business model. They have no product. What they have, or maybe what I should more accurately say they had, is this patent on remote patient monitoring and diagnosis. So on using a phone or a video system or whatever to talk to a patient remotely and give them some kind of diagnosis remotely.
And it's an app?
It's nothing.
Oh.
They have no business model. They have no app.
Oh, it's just an idea.
Right.
Can you elaborate on that?
Sure. Here's a story that I think is a pretty good encapsulation of the patent trolling problem. There's this man who lives in Omaha who EFF has gotten to know over the years, who had a telehealth company. It's a company called My Vitals. And it's a company that you can use for kind of remote patient diagnosis. One day, when his company was kind of just getting started, when it had been around for a few months, he got this demand letter from a company called My Health. My Health said that it owned the patent on what his company was doing. Now, when you look at the My Health patent, it is remote diagnosis. It is exactly that. It is the practice of a doctor talking remotely to a patient and giving them some kind of prescription. This is just a classic example of a patent that is sort of an abuse of the patent system, because this is a practice that has existed in some form or ever for a long time. But they filed this patent that claimed doing this practice that it has existed for a long time over the internet. And so Justice, that's the name of the gentleman, Justice Decker, he received this demand letter for, I think it was $25,000 when he was this entrepreneur who had just started a company with maybe 1 or 2 employees. He could not afford to pay that. Oh, and by the way, they were also suing or sending these similar demand letters to all of his competitors, to all of the companies doing this same kind of work.
And he wasn't in the market at all.
Well, no, he was. But the patent troll,
No, that's what I mean, the patent troll.
Company, My Health.
They were not even in the market. They weren't trying to develop anything. They just held the patent.
Right. They were not a practicing company. You can look on their website and there's no product. There is no service being offered. Their entire business model was just sending people these demand letters threatening to sue them and getting these licensing payments from them. Oh, and by the way, it's such a funny detail. They were at the same time also doing trademark trolling. They were also threatening people for using the phrase "my health." It's like in EFF's view, these companies, they're kind of an unfortunate side effect of a loophole in the law. The reason why the patent system exists, and it says this right in the Constitution, is to promote innovation. These companies that don't do anything except for sue actual practicing businesses are like, there's no innovation happening there.
Right, because they're stifling them.
Right. So we talked earlier about the Alice v. CLS Bank decision. Fortunately, the My Health patent was invalidated under Alice.
Oh, so it was fought successfully.
Right. And so Justice still has his business, and he is still going along.
How are companies like that, I guess, legal?
That is a very good question. And like, we have tried over the years to get in place some good reforms to make patent trolling harder. Lots of patent trolls' tactics, when it really comes down to it, are just taking advantage of the fact that for a practicing company on the defending end of a patent infringement suit, fighting that case is going to be very expensive. So they'll offer them this fee that is a lot of money, but still less money than fighting that in court might be. So there have been various attempts in Congress over the years to essentially make patent trolling harder. And there have been some important wins. We've talked, of course, about the Alice v. CLS Bank decision already. These low-quality software patents are kind of the perfect fodder for trolling because you can find so many practicing companies that supposedly infringe on them.
And they're probably not at stages where they have a ton of capital where they can go to litigation over this.
Right.
They just have to settle.
Right, exactly.
I've heard the same thing with ADA compliance, that there are firms that go specifically after small to medium-sized businesses that have, ADA infractions. Is that the right word? That just aren't 100% compliant. Same with, this is probably on a much lesser scale, but domains. I know people will, buy a ton of domains just to hoard them. So people have to pay them when they want to use it. But it's interesting. So what makes a patent legitimate or illegitimate?
That's a good question. And I should say again here that I'm not a lawyer. But what a patent is supposed to be on under the law is, one, an actual invention, like not just the idea of hosting a talk show or of doing remote patient monitoring or whatever, but an actual invention. Two, it's supposed to be something that did not exist previously, that was not commercially available, that you can't find existing documentation for how to do at the time that the patent was filed. And then three, the patent application itself should explain how to do the invention. And this is where you get to what's supposed to be the purpose of the patent system. Is it's essentially this bargain that society makes with an inventor, where the inventor gives society this information about this new process that they've discovered, whatever it is. And in return, society gives the inventor a temporary monopoly on that invention, so that they can, one, make money for it, and two, so that they can scale it.
Because they're the ones that put in the risk, the work, the research and development. Is that what you're saying? So therefore they should be able to reap the benefits for at least a little while before other people start jumping on that.
Yeah, there's I think questions about like without that patent. Again, and this is in this kind of idealized version of the patent system that we're talking about right now, how you would effectively be able to scale. How you would be able to, if you were operating only on trade secrets, only on if you're operating only on this secret thing that you know about how to improve a certain product in some certain way that nobody else knows, then it would be hard to scale that business beyond just you having your little shop on the corner where you're selling whatever this thing is. But again, if you take those ideas of what the patent system is supposed to be, one, that it's supposed to be on actual inventions, and two, that the patents are supposed to be a trade of actual useful information to society, and then you look at these sort of low quality software patents that we've been talking about, you realize that something is very wrong. And this is why I said this a second ago, that when you ask that question to professional software developers of whether the information in the patent literature is useful to them or not, the answer is that it's not. Like the My Health patent is a good example. You look at that patent application, and it describes this process of the remote monitoring or whatever, and it has these flow charts of, doctor contacts patient, arrow goes over here. That's not useful information.
Wait, so that's
because the idea of that business, that's really easy to think of.
Right.
The hard part is doing it.
Right. Right.
But when you have these low quality software patents, you're essentially rewarding the idea more than you're rewarding the work.
Right. That's it. Okay.
Here's a funny side note about the My Health patent, where it originally came from is the University of Rochester. And that's pretty common for these software patents that end up in the hands of trolls. A lot of them actually originate at universities from research that was funded by the government.
Really?
Yes.
How is that?
There is a law that was passed, I think in 1981, called the Bayh-Dole Act, that allowed people who file patents, people who develop inventions as a result of government funding or government contracts, to be able to patent those inventions and license them out. And there are a few universities that have made a lot of money on this system. And there are lots that don't make any money on this system and in fact lose money on it, but still file lots and lots of patents on government-funded research. And license those patents to third parties.
Is that something that you guys work to make, lawmakers, whoever, more aware of?
We have tried. It's a complicated issue. If you actually go to reclaiminvention.org, you'll see this little site that we put together about this problem, where we encourage people, including students, faculty, etc., to reach out to their university leadership and say, hey, let's just at very least make it a part of our patenting process that when the university is licensing a patent to a third party, they will do a little evaluation of that third party and whether it's a troll. And, I certainly don't want to paint the universities in a bad light here. And in fact, a number of them do try to take certain precautions to make sure that the patents are ending up in the hands of companies that are actually going to enact the invention in the patent and are not just non-practicing entities. But yeah, it is a big and complicated problem.
Hey everyone, thanks so much for watching the episode. If you're interested in contributing to the conversation and supporting the show, there's 2 easy things you can do. 1, click subscribe, and 2, visit our Patreon page where you get exclusive access to the Exploring Minds community.